for legal eagles exclusively. Text sourced from www.ibm.com. Abridged and recorded for teaching purposes. DORA, the Digital Operational Resilience Act, a European Union (EU) regulation that creates a binding comprehensive information and communication technology (ICT) risk management framework for the EU financial sector. DORA establishes technical standards that financial entities and their critical third-party technology service providers must implement in their ICT systems by 17th January 2025. DORA applies to all financial institutions in the EU. That includes traditional financial entities such as banks, investment firms and credit institutions, and non-traditional entities including crypto asset service providers and crowdfunding platforms. DORA also applies to some entities typically excluded from financial regulations. For example, third-party service providers that supply financial firms with ICT systems and services, like cloud service providers and data centers, must follow DORA requirements. DORA also covers firms that provide critical third-party information services, such as credit rating services and data analytics providers. The European Supervisory Authorities, ESAs, are in charge of drafting the Regulatory Technical Standards, RTS, and implementing technical standards, ITS, that covered entities must implement. These standards are expected to be finalised in 2024. The European Commission is developing an oversight framework for critical ICT providers, which is also expected to be finalised in 2024. Once these standards are finalised and the January 2025 deadline has arrived, enforcement will fall to designated regulators in each EU member state, known as competent authorities. The competent authorities can request that financial entities take specific security measures and remediate vulnerabilities. They'll also be able to impose administrative and, in some cases, criminal penalties on entities that fail to comply. Each member state will decide on its own penalties. ICT providers deemed critical by the European Commission will be directly supervised by lead overseers from the ESAs. Like competent authorities, lead overseers can request security measures and remediation and penalise non-compliant ICT providers. DORA allows lead overseers to levy fines on ICT providers amounting to 1% of the provider's average daily worldwide turnover in the previous business year. Providers can be fined every day for up to 6 months until they achieve compliance. As part of the risk assessment process, entities must conduct business impact analyses to assess how specific scenarios and severe disruptions might affect the business. Entities should use the results of these analyses to set levels of risk tolerance and inform the design of their ICT infrastructure. Entities will also need to establish business continuity and disaster recovery plans for various cyber risk scenarios, such as ICT service failures, natural disasters, and cyber attacks. These plans must include data backup and recovery measures, system restoration processes, and plans for communicating with affected clients, partners, and the authorities. Covered entities must establish systems for monitoring, managing, logging, classifying, and reporting ICT-related incidents. Depending on the severity of the incident, entities may need to make reports to both regulators and affected clients and partners. Entities will be required to file 3 different kinds of reports for critical incidents: an initial report notifying authorities, an intermediate report on progress toward resolving the incident, and a final report analysing the root causes of the incident. Entities must carry out basic tests, like vulnerability assessment and scenario-based testing once a year. Financial entities judged to play a critical role in the financial system will also need to undergo threat level penetration testing, TLPT, every 3 years. The entity's critical ICT providers will be required to participate in these penetration tests as well. Technical standards on how TLPTs should be carried out are forthcoming, but they're likely to align with the TIBER EU framework for threat intelligence-based ethical red teaming. For Legal Eagles exclusively. Thank you.